Good morning, this is your Kelso Report for Tuesday, November 22nd, and I'm your host, Clark Kelso. I suspect that all of us have participated in phone conversations with customer service representatives where the conversation begins with a representative or a recorded voice saying something like, "Is it okay if this phone conversation is monitored or recorded for quality control purposes?" And I also suspect most of us answer yes to this question. Because we want the customer service, quality control by supervisors is not a bad thing, and we really don't care about being recorded. Well, it turns out, of course, that this is not just the company being thoughtful or considerate, it's the law. According to the 4th District in Kite v. Cash Call, securing that consent to being monitored or recorded is necessary to avoid potential liability under Section 632 of the Penal Code, which imposes liability on a person or corporation who intentionally, quote, eavesdrops upon or records a confidential communication, close quote, and engages in this conduct, quote, without the consent of all parties, close quote. The issue arose in a class action brought against Cash Call, a consumer finance company. The plaintiff sought the statutory penalty of $5,000, presumably for each such call that was made without consent. The problem for Cash Call was that while their automated voice system gave the standard notification on most incoming calls, it clearly was possible to speak directly with a customer service rep without being warned about the possibility of monitoring, and outgoing calls from the company had no warning at all. The company tried to argue that when the person doing the eavesdropping is part of the same corporation as the customer service representative, there really are only two people on the line, the customer and the company. Well, the appellate court rejected this argument, explaining that in Flanagan v. Flanagan, the California Supreme Court held that Section 632 protects an individual's right to know who is listening to a telephone conversation. Consistent with this holding, we conclude the statute applies even if the unannounced listener is employed by the same corporate entity as the known participant in the conversation. On remand, the trial court will still have to deal with a number of issues under Section 632, including trying to identify which members of the class actually knew that phone calls were being recorded and consented to the recording, and whether the conversations actually were confidential communications under the statute. But either way, next time you hear that recorded message, you can know that you've got a company that understands it has an obligation under Penal Code 632 to let you know that somebody else may be listening in on your conversation. And now our one-liners. First, in the area of government law and contracts. In Retired Employees Association of Orange County versus County of Orange, the California Supreme Court answered a certified question from the Ninth Circuit in a case challenging the validity of certain changes that Orange County made to its health benefits program for retired employees. The Ninth Circuit asked the following question, quote, whether, as a matter of California law, California County and its employees can form an implied contract that confers vested rights to health benefits on retired county employees, close quote. After conducting an exhaustive review of basic principles of local government law as well as the law of contracts, the Supreme Court held that a county may indeed be bound by such an implied contract. Although Section 25300 of the Government Code requires that compensation of county employees be addressed in an ordinance or resolution, the statute does not prohibit a county from forming a contract with implied terms, inasmuch as contractual rights may be implied from an ordinance or resolution, when the language or circumstances evidence an intention to create private rights of a contractual nature enforceable against the county. Whether the implied terms create vested rights, according to the Supreme Court, is in turn a matter of the parties' intent. The case now goes back to the Ninth Circuit for additional proceedings. We have 3 appellate jurisdiction cases in the Ninth Circuit. It was a big day for jurisdictional issues. In United States v. Beltran-Valdez, the Ninth Circuit held that the district court's order denying the defendant's request for appointment of new counsel was interlocutory and did not fall within the collateral order exception for appellate jurisdiction. Now, to be within the collateral order exception, an order must conclusively determine the disputed question, resolve an important issue completely separate from the merits of the action, and be effectively unreviewable on appeal from a final judgment. Without deciding whether the first 2 requirements were met, the Ninth Circuit held that denial of a request for appointment of new counsel is reviewable on appeal from the final judgment, in exactly the same way as post-conviction review of asserted Sixth Amendment deprivations, such as denial of a right to represent oneself, is fully effective in review of the final judgment. So, the court dismissed the appeal. Next, in NLRB versus Legacy Health System, the Ninth Circuit applied Section 10b of the National Labor Relations Act in holding that it lacked jurisdiction to hear arguments that were not urged before the National Labor Relations Board. The appellant argued that it wanted to appeal only the terms of the board's remedial order, and it could not even fashion that argument until the order was issued. Well, the board filed a petition to enforce the order only 3 days after issuing its opinion, and the appellant argued it did not even have an opportunity to request to present its argument to the board. The Ninth Circuit rejected this position, noting that the appellant could have and should have filed a motion for reconsideration with the board, since the board retained concurrent jurisdiction over the matter for 28 days after issuing its opinion. In these circumstances, according to the court, Section 10e deprives the appellate court of jurisdiction to review the board's order. Our third appellate jurisdiction case, in United States v. Taddeo, the Ninth Circuit considered an appeal of a district court's decision to reduce a prisoner's sentence by 2 years, based in part upon the assistance the prisoner provided to the investigation and/or prosecution of others. Federal Rule of Criminal Procedure 35b does indeed authorize a district court, on the government's motion, to reduce a defendant's sentence if the defendant, after sentencing, provides substantial assistance in investigating or prosecuting another person. There were 2 issues on appeal. First, in settling upon the 2-year reduction, the district court considered factors other than whether the defendant provided assistance. The Ninth Circuit held that once the district court determined the defendant has provided substantial assistance, the court then may consider other factors in determining upon the reduction of sentence, in order to ensure that the sentence ultimately imposed accords with the purposes of sentencing that Congress has articulated. Second, the Ninth Circuit held that it lacked jurisdiction to review the court's exercise of discretion in choosing the length of the sentence reduction. Its appellate jurisdiction in this type of matter is limited to determining that the district court applied the correct legal standard. Having concluded that the district court did indeed use the correct legal standard, the Ninth Circuit dismissed the remainder of the appeal for lack of jurisdiction. Next, we have an interesting remedies case. In Noxion versus AOL, the plaintiffs alleged that AOL had wrongfully inserted footers containing promotional messages into emails sent by AOL subscribers in violation of federal and state laws. The parties negotiated a settlement, part of which included cypre distributions to a number of charities selected by the parties and a retired judge who was acting as a settlement judge. Everyone agreed that the maximum recoverable in the lawsuit would be about $2 million, and that would be on behalf of a class of 66 million subscribers, which translates to the princely sum of 3 cents per subscriber. Well, the charities selected, for example, the Legal Aid Foundation of Los Angeles, the Federal Judicial Center, and the Boys and Girls Club of America, had nothing whatsoever to do with the underlying claims, nor did the charities overall have a nationwide scope to match the class. The Ninth Circuit held that the Cypre awards had to be reversed, because they were not guided by the objectives of the underlying statutes and or the interests of the silent class members. As the court noted, a growing number of scholars and courts have become concerned that the Cypre doctrine, unbridled by a driving nexus between the plaintiff class and the Cypre beneficiaries, poses some dangers to the fairness of the distribution process. In short, it becomes a way for plaintiff's counsel, defense counsel, and even the judge to target monies to their favored charities. The Ninth Circuit sent the case back for reconsideration of the Cypre awards. Next, we have a couple of cases involving sanctions. In Doe versus United States Swimming, the 6th District affirmed $5,200 in sanctions against the defendant in a case alleging damages resulting from sexual molestation and abuse of the plaintiff, who was at that time a 15-year-old female, by her swim coach, who was employed by U.S. Swimming. As part of discovery, plaintiff sought a list of all of the coaches employed by U.S. Swimming against whom claims of sexual misconduct had been alleged. Ostensibly to protect the privacy interest of coaches who may have been charged but never proven guilty, the defendant produced 1,800 documents that did not appear to be in any logical order, where each and every specific information necessary for assembling the documents in a logical order, for example, incident numbers, complaint numbers, dates, regions, teams, and so on, had been redacted, as had virtually all other information necessary for plaintiff to determine the date of the complaint, the nature of the complaint, witnesses, and what, if anything, was done in response to the complaint. The trial court sanctioned the defendant for failing to comply with its discovery orders, and the 6th District affirmed, finding that the defendant had not provided any substantial justification for its failure to comply and its substantial over-redaction of discovery documents. Next, speaking of sanctions, the 6th District in Hopkins and Carley versus Jens affirmed the imposition of sanctions against the defendant, who was a lawyer, as well as his counsel, arising out of an entirely unsupported and nearly incoherent motion to set aside a judgment confirming an arbitration award for unpaid attorney's fees. The motion based supposedly on mistake, inadvertent, surprise, or excusable neglect. The motion made no real effort to substantiate any of the grounds alleged for setting aside the judgment, and the 6th District agreed with the trial court that many of the arguments were simply incoherent. The court's anger comes out nicely in the closing paragraph, which reads as follows, quote, "The court below quite properly found that the purpose of the motion was not to assert any arguably legitimate legal right, but to frustrate and impede when the defendant and his lawyers knew was an inevitable defeat. Indeed, it appears to this court that if this case involves any chill bearing on the propriety of a sanctions award, it resides not in any tendency to inhibit zealous advocacy, but in the enormous snow job the defendant and his attorneys have heaped upon their opponent, the trial court, and this court." Close quote. Ouch. Next stop would appear to be the state bar for disciplinary proceedings. Next case involves juvenile court in In re Hunter W. The juvenile court called for the start of a hearing on a change of circumstances petition under Welfare and Institutions Code Section 388, pursuant to which the father and mother were going to present arguments in favor of reunification services. Both father and mother had checked in at the 8:30 calendar call, but when court reconvened at 10:20, neither was present. Father's counsel informed the court that the father had gone to his treatment program to obtain a signed certificate to introduce an evidence, and he was expected back by 1:30. However, the court refused to put the matter over to the afternoon, proceeded with the hearing in the absence of the father and mother, ruled against them, and ordered termination of parental rights. The second district held that the juvenile court abused its discretion in failing to hold open the hearing from the morning to the afternoon so that the father and or mother could be present. They were the only witnesses presenting evidence in support of their motion, and the juvenile court did not give any reasons why it would be inconvenient for the court to hold the open hearing. As the appellate court noted, given that the issue being dealt with is a matter of fundamental rights and interests, the juvenile court had a special obligation to try to see to it that the parents had a fair hearing and opportunity to present their case. And that's it for today's Kelso Report. Have a great day in the law.